we're going to have Judge Huff, Judge Ozumba, Stephanie Brown, and Laura Duque present on Article 16.22 process and accessing care through special conditions bond. First off, we have Judge Huff. Honorable Judge Yolanda Huff presides over County Court Number 12 and the Mental Health Court. She obtained her undergraduate degree from the University of Texas at Austin and her JD from St. Mary's Law School. Before running for judge in 2018, Judge Huff was also a practitioner in Bexar County for 22 years, where she handled criminal, child protective, and personal injury cases. She served twice as president for the San Antonio Black Lawyers Association and served 12 years on the advisory board for the Dispute Resolution Center. She has been a member of the San Antonio Criminal Defense Lawyers Association and was a staff attorney for the Felony Drug Court for 2 years. She currently serves on the Bexar County Domestic Violence Committee and the Bexar County 16.22 Progress Committee. Additionally, one of her greatest accomplishments since taking the bench has been the founding of the Bexar County Specialty Courts Coalition. And in 2021, she was invited by the Supreme Court of Texas and the Texas Court of Criminal Appeals to serve on the Judicial Commission on Mental Health. Next off, we have Honorable Judge Grace Ozumba, presides over Court County Number 2, which handles criminal misdemeanor offenses. A veteran officer, she retired from the U.S. Army after 20 years of service, and in 2005, she graduated from the St. Mary's University School of Law. Judge Ozumba has extensive experience with problem-solving courts, including Veterans Treatment Court, Drug Court, and DWI Court. She served as a board member for the Therapeutic Justice Foundation and has served as a panelist covering Article 16.22 process for the Judicial Summit on Mental Health. Additionally, she was recommended by the Judicial Commission on Mental Health to serve on a statewide sequential intercept model MAPLE. Judge Ozumba was born in Nigeria and has been working in San Antonio for 18 years. Next is Stephanie Brown. She is the first assistant public defender of Bexar County. She has been employed with the Public Defender's Office since 2015 and played an intricate part in the development of the Bexar County Magistration Program. During her 18 years of practicing law, the majority of her career has afforded her the privilege of working as a public servant in the roles of Assistant District Attorney and Assistant County Attorney for Bexar County, Atascosa County, and Comal County. Stephanie has worked also as a solo practitioner in the criminal defense firm. And then we have Laura Duque. Laura Duque graduated in 2006 from the University of Texas at San Antonio with a bachelor's degree of arts in criminal justice. In 2007, she started working for Bexar County Pretrial Services for 12 years as a pretrial bond officer and worked her way up to a pretrial supervisor. While working for pretrial services, she attended and graduated with a Master's of Science in Criminal Justice from Sul Ross State University and is currently enrolled in the PhD program in Leadership and Management at Walden University. Ms. Duque is currently the Population Impact Control Unit Manager for Bexar County. Her team provides assistance to all criminal courts, diverts inmates into placement and services for the Bexar County Jail, and collaborates with various governmental departments to improve and release of inmates from custody. Thank you, presenters, for joining us. Judge Huff.
Thanks you, everyone. I am, like Melissa said, Judge Yolanda Huff. I do preside over County Court 12 and the Mental Health Court. I'm going to go over the 1622 process with Judge Ozumba today. I know a lot of the attorneys on this Zoom have heard me often talk about the red envelopes in the files. So the red envelopes are the end result of the 1622 process. So what really kicks off the whole 1622 process is, of course, some form of police intervention or detention of a defendant. The law, according to the Sandra Bland Act, law enforcement, well, the Sandra Bland Act did improve this aspect of law enforcement. They must divert when appropriate and have a good faith effort to divert an individual that's suffering a mental health crisis or suffering from effects of some kind of substance abuse. Now, however, having said that, officers have considered they have considerable discretion in responding to a situation in the community involving a person with a mental illness or intellectual disability who may be engaging in criminal conduct or experiencing a mental health crisis or both. So I call that a pre to the 1622 process, or my kids will call that, Mom, that's a prequel to the show. So we'll go to the next slide. Now, what is the 1622 process? Okay. Article 1622 of the Texas Code of Criminal Procedure details a procedure for identifying a person's possible mental illness or intellectual disability at the earliest stages of and throughout a criminal proceeding. Now, under 1622, a magistrate must, under certain circumstances, order an expert to interview the defendant and otherwise collect information regarding whether the defendant has an MI or IDD in order to alert the necessary stakeholders if the resulting report indicates possible MI or IDD or ID. Now, I'll tell you what exactly is the 1622 report. It is a report provided to the magistrate under Article 1622, 16.22. It is a limited purpose tool. It is a report of information collected in an interview regarding a person's possible MI or ID. The interview is a collection of information, and written reports must be performed by a qualified professional. And I don't really have time to get into the qualified professional, so you guys have to take have faith. So what an interview, before I begin step one, and I should tell you guys that just for purposes of explaining this to you, these I label it step one, step two. That's not necessarily how it's done. It's just in order for me to explain it in a cohesive manner to you guys. So before I get to step one, I'll say to you guys also that what 16.22 is not. A 1622 report is not a diagnosis of MI or ID. A 1622 interview is not a full competency evaluation of the Texas Code of Criminal Procedure for 46B, incompetency to stand trial, or 46C, insanity defense. And also a 16.22 interview is not the mandatory jail screening, which must be completed by a jail employee for all inmates. Okay, so we'll start off with when an individual is arrested for an offense that is a Class B or higher, the sheriff must provide written or electronic notice of credible information. And how the sheriffs get this credible information is from several sources. The continuity of care query that Jacob talked about earlier, the TCJS suicide screening, a magistrate's own observation of MI or ID at initial appearance or arraignment. These are different sources of how a sheriff would get credible information identifying if someone possibly has ID or MI. This is all done within 12 hours of arrest. Now, there's a lot of information that goes into that 12 hours of arrest. It used to be 72 hours, but under the Sandra Bland Act of 2017, it got reduced to 12 hours, which was great. That was a very good thing. Okay, so the 12 hours, according to Article 22, does not specify the duration of the notice. Rather, the sheriff must provide within 12 hours whether of having custody of a defendant and credible information is received. So say, for example, the person is taken to custody, and a lot of times they may be under the influence of some kind of substance, and it could be a day or two later. And at that point, the sheriff's notices and receives credible information. The process starts at that point. And I think that the rules were left kind of open like that on purpose, because we all know that probably does happen a lot. So Article 22 specifically left that duration open like that. The sheriff now sends the notice of credible information to the magistrate. The magistrate now must make a reasonable cause determination. Now, he does this by, he reviews the notification from the sheriff. He reviews charges of the defendant, his criminal history. He meets the defendant. He communicates with the MHA, which is the local mental health authority, the LIDDA, which is the local authority on developmental disabilities authority, and the mental health providers. If no reasonable cause is found, there's no further action taken at this point. If reasonable cause is found, the 16.22 process continues. The magistrate checks to see if a prior 16.22 report was done in the preceding year that indicates MI or ID, and he is free to use that report. And then he can proceed with the 16.22 process using that prior report. If there's not a prior report, the magistrate shall order the mental health provider to conduct the 1622 interview. And that's where I'm going to let Judge Uzumba take up from that point. And if you guys have any questions, we're under constraints of time, so I'm trying to go through this very quickly. And it's a lot to cover, but you can put your questions in the chat, and I'll try to get to a lot of these questions afterwards. So I'll let Judge Uzumba continue from here. Thank you.
Thank you, Judge Huff. So as Judge Huff had mentioned, with the Article 15.17 hearing that the magistrate should conduct, is actually the duties of the arresting officer and the magistrate. That's what that article is entitled. And as you see that they conduct the hearing as Judge Huff has described, and they have considered a personal bond, a mental health bond. And under Article 17.03, and these articles are found in the Texas Code of Criminal Procedure. Under that, that one addresses matters of the personal bond. Specifically, what the magistrate should consider is specifically detailed in Article 17.032, what release on personal bond of certain defendants with mental illness or intellectual disability. So once the local mental health, the magistrate must confer, as Judge Huff had mentioned, with the local mental health authority, as well as the local intellectual and developmental disability authority and the mental health provider to interview that defendant and make that report. That report must be returned in 96 hours if the defendant is in custody, or 30 days if the defendant is out of custody. Now, the 16.22 was amended by the acts in 2017. So this has been around for a little while. The emphasis is just being made on it as the 1622 process committee doing a wonderful job in making sure that we're disseminating this information and sharing it with all who are involved in the entire legal system. So that the 85th legislature enacted this on the 27th of May, 2017, and it became effective on the 1st of September, 2017. So this report is intended to be distributed to district county judges, the district county attorneys, as well as defense attorneys. Now, this is very important, and of course, the judges. It is recommended that the district and county clerks get it, but actually in Bexar County, they're the ones who get it, and it's in the court file as well. So it is available. It does not have HIPAA restrictions on it. So it is important for the attorneys expressly to be able to look into this. The 1622, also known as Senate Bill 1376. I don't know if I have that number correct, but some people do refer to it as that type of form. I personally—
I was going to add, Judge, 1326.
26, thank you. I knew I had about the number. Thank you very much, Jessica. I personally refer to it as a 16.22 form. And it is really important that that written assessment, that it should be considered during the punishment phase as part of a pre-sentence investigation or in connection with impositions of conditions following placement on community supervision, including deferred adjudication community supervision. That is the main import of that 1622 form. And we judges and the triangle that is formed between the judge, the prosecutor, and the defense attorney really should pay attention to the information collected on that form. So these are the options for the trial courts. To continue the criminal proceeding against the defendant or resume and initiate a competency hearing. Sometimes the 1622 form, as I have seen with some attorneys, has indicated to them that, hey, there may be a competency issue here. It kind of gives them the idea that, oh, maybe this is the reason I had difficulty communicating with my client. So it can lead to that, and that would be covered under Chapter 46B of the Texas Code of Criminal Procedure, which is entitled A Competency to Stand Trial. Now, they can refer the person to an appropriate specialty court, such as the court that Judge Huff presides over, the mental health court. And then there's other dual diagnosis courts and other court, all of the other specialty courts, depending on their eligibility. They can also consider the report during, of course, again, as I mentioned, during the punishment phase and the setting of conditions under community supervision and any resources that that person may need. We need to go ahead and also consider that report in bond issues and any services that may be provided. Ladies and gentlemen, thank you so much. I saved us a couple of minutes for questions.
Thank you, Judge. And Stephanie?
Good morning, everyone. Prior to 1622 becoming the major focus that it is as of recent, in 2015, the Bexar County Public Defender's Office was tasked with the goal of representing mentally ill and indigent people at CMAG, the Central Magistrate Unit on Frio Street. I believe everyone who has been in the system a while should be familiar with CMAG. At that time, we could only see as many as 50 people we were able to recognize as mentally ill and indigent and go through the process of trying to get them into our program developed in conjunction with the Center for Healthcare Services, CHCS. After 2018, JAC came into existence, the Justice Intake Assessment Center, or the Justice Intake Assessment Annex. This is where we moved and the Sheriff's Office moved in order to handle all of the arrested persons in Bexar County. And if they were arrested by any law enforcement agency, they were all brought to JAC. They're all brought to JAC at one point or another. We moved from representing just the indigent, mentally ill people at JAC to representing everyone who was arrested and brought into the Justice Intake Assessment Center. While our goal is still to represent the mentally ill, we now see everyone. In addition to those people who are deemed to suffer from a mental illness, we are also looking to provide services for those who are dealing with substance abuse issues. We are dealing with, of course, making sure we can get the lowest PR bond possible. I mean, a personal bond for everyone. And we are also looking to get the lowest bond amount possible. But our goal still is to find those mentally ill people who need our help. And the way we go about doing that, as Jacob mentioned in his speech and in Judge Huff's presentation, the continuity of care query is one of the major focuses. In addition to that, we're looking at the booking slip, those 4 questions on the back of a booking slip. The booking slip questions are as simple as, have you ever been diagnosed with a mental illness? Have you ever been prescribed meds by a mental health provider? Are you currently suicidal? And have you ever attempted suicide? If we get a yes to any of those questions, then we're tasked with the goal of trying to make sure that those people are assessed first with pretrial services. And on the screen, you are currently looking at the pretrial risk assessment interview form. That form basically tells us all of the demographics about our client found during that assessment. At the same time that is going on, we have also informed the clinicians from CHCS that we have a potential client. And they are going to speak with that client also to determine if there is a mental health issue, whether it is a current mental health issue, a previous mental health issue, as a continuity of care query provides. If it is the fact that they are in treatment, if they are currently in treatment, we're still going to try to get them to continue that treatment and get them out on a PR bond that is now termed continuing services. And this information, this mental illness, may come from a variety of other places besides that CCQ, the booking slip, the police report. It can also come from something one of the officers observed within the detention center. It can come from something we've spoken to our client and we've determined that there may be an issue there. We can also get our information from the clinicians, the judges, other staff. The most important one I thought was, as of recent, the ADA called our attention to a client in a case she was reviewing with the officer prior to filing the case. She called our office to say, hey, I think you guys might want to look into helping this person. So again, we get our information from everyone and we provide that information to the clinician when we let them know this is someone we may need to help. So when we're talking about the opportunity to get these people out on a mental health treatment, mental health PR bond, we are asking them basically the questions on the back of those four questions on the back of those booking slips. And we're trying to elicit more information so that we can provide that to the clinician. So what we tell them is that if you want to participate in our program, you have to agree to attend all of your doctor's appointments. You have to take all of your medication prescribed and discuss the problems with the doctor if the meds you're not handling them. You want to keep in touch with your pretrial officer. You want to make all of your court appearances as scheduled, and you want to stay out of trouble. So if that person is PR eligible, according to 1703, as mentioned by Judge Uzumba, then we're dealing with 17032, which tells us what those persons who are eligible for mental health treatment, what we can give, what we can do with them according to the Texas Code of Criminal Procedure. So if they are eligible, we've informed the pretrial services with the risk assessment, as I said. The clinician is now doing her assessment or his assessment. And if it is a PR, mental health PR bond, they're going to be released on what's called a fast track. That fast track document is an assessment performed by the clinician, which has so much information in it, which provides how much or how long or what it is the client is dealing with. All of the information that's provided in that fast track is then given to us along with that PR risk assessment from the clinicians. And we provide that documentation to the judge. And during magistration, we've indicated to the judge that this particular client may be a special issue matter, and we will be submitting documentation later. And the judge knows that is code for a mental health case of some sort. So once we acquire all of that paperwork from the clinicians and provide it to the judge will basically review it, having already seen the file, having already magistrated the client, and she will either grant it or deny the mental health PR bond or the continuing services PR bond. Once this information has been provided, we update our system. Everyone throughout JAC will update their systems, and we know our client will be, whether or not our client will be released on a mental health PR bond before the end of the day. We try to meet with our client again to let them know the judge has either granted or denied it. We review what it is that's expected of them again, those items I mentioned earlier. Take your meds, stay out of trouble, make all your court appearances, keep in touch with the pretrial officer, and see your doctor as required. And once we have gone over this information with them and make sure that they do understand, there's a short process for, there is a little longer wait for them to make sure that all of the ducks are in order at JAC, and then the person is released into the Center for Healthcare Services through that fast track. At that time, the Center for Healthcare Services will meet with them, will set up future appointments with them, will ensure they understand what's about to take place in their process, and they will provide them with transportation home. All of the information that is gathered is summarized and put into this collection information form for mental illness and intellectual disability. This information is provided to defense counsel in the e-discovery file. This is what you need to look for first to find out if you are dealing with a client with mental illnesses of any type, so that you can make sure your client is still on board to try to receive those services. If you have questions about what it is that they're going through, pretrial services is really good about answering them. Laura Duque will discuss the special needs, special conditions that come from that. But all of this information is taking place at JAC, and it sounds simple. It is not. We are dealing with as many as 200 people in a day. We are getting out as many as 30 to 40 people in a month. And that's after the clinicians have seen at least 3,000 people. And that's just up to this month, from January to April. The clinicians have interviewed at least 3,000 people. Not all of those people are mentally ill, are eligible. There are many indications that although they may have illnesses, they can't be a part of this program. But the idea is everyone coming through JAC is seen and they are questioned, and we're trying to determine that no one leaves that place without some type of recognition, as 1622 indicates. Thank you.
Thank you, Stephanie. Ms. Laura, you're next.
Hello, everyone. So once the person's released from custody, I'm going to speak on the special conditions of bond and some of the diversion programs that our department offers and participates in with Bexar County. So the diversion programs, the following are some of the programs involved within the judicial system in Bexar County. Diversion programs from the Justice Intake Assessment Annex Center, which is what Ms. Brown was speaking of. And then the 48-hour bond hearing is one of the diversion programs. If they're not released from the Justice Intake Assessment Center, that's the next step that they will fall into, which is the 48-hour bond hearing. And then if they're not released at the bond hearing, then the jail diversion programs that I'm going to speak on are some of the programs that are offered to them once they are booked into the Bexar County Jail. The Justice Intake Assessment Annex screens individuals for diversion programs. These programs consist of being screened for mental health and substance use by the Center for Healthcare Services and Pretrial Services. This is the program that Ms. Brown was speaking of. If approved for release by the magistrate judge, the individual is diverted from custody to outpatient treatment with CHCS for either mental health or substance abuse treatment. Once released from custody, the individuals are assigned to a pretrial officer for supervision of the condition of release. So even though they are diverted from GIA, they still are assigned to an officer or a case manager that will follow their process throughout their release from custody. So the next step is the 48-hour bond hearing court. This is the process where the individuals are gone. They're going to a bond hearing. They're still booked into custody. They're not released at the magistrate. They are booked into the Bexar County Jail. So they go to this bond hearing, which consists of misdemeanor and felony cases for individuals that have been in custody for longer than 48 hours and have not posted bond since magistration. Majority of the time, these are new on-site charges. So the outcomes are either at the bond hearing, they are granted a personal recognizance bond at the hearing, or a bond reduction, or the judge can take no action. So either the person is released at this phase in the step of process, or they remain in the Bexar County Jail, and then they move on to the next step, which is the diversion programs. So once individuals are booked into the Bexar County Jail, they're screened for multiple services through the Bexar County Population Impact Control Unit. If approved by the judge for release, these individuals can be transferred to local substance treatment facilities, housing programs for their continued support once they are released from custody. Crosspoint Jail Diversion Program, that's a program that we have through the partnership with Crosspoint Transitional Housing Program for individuals that are screened for residential housing services. If approved for release by the judge, the offenders are transferred from custody into the Crosspoint Transitional Housing Program. The program includes 24/7 residential support and case management for the offenders once they're released. Also, once they are released from these diversion programs, They are all assigned to a case manager or a pretrial bond officer that is with pretrial services that monitors their support once they are released from custody. So each one of these diversion programs will also have a pretrial officer and to help with their continued support and to make sure that they appear for court. So the Jail Outreach Diversion Program is a partnership with Haven for Hope for individuals that are screened for homelessness, substance use disorders, and mental health. If approved for release by the judge, individuals are transported to the Jail Outreach Program at the Haven for Hope facility. This program includes 24/7 housing on campus for the individuals, substance and mental health treatment that's provided there. They work with multiple programs, that are out there in the community to help with their treatment and or mental health treatment. They also provide residential support and they also have case managers there at Haven for Hope that work with individuals to help support them and their outcomes. So the special conditions of release, if someone is granted a PR bond or a commercial bond, they can be assigned to one of these conditions of release or multiple conditions of release that are ordered by the judges as a condition of their release from custody. So the special needs unit is one of the condition, residential treatment facility, outpatient treatment, transitional housing programs, drug and alcohol testing, no contact order, GPS, which is full, they can order full or partial house arrest, and then some type of alcohol monitoring device. These are all conditions, some of the conditions of release that are for the offenders that are released from custody that the judges can order at any point of time. And that is all I have for you. Thank you.
Okay, we have a couple questions for you guys. Let me stop sharing my screen. One from Nancy. What options do community supervision officers have when they believe a probationer may be mentally incompetent and facing an MTR, motion to revoke?
I guess I will answer that, even though I'm not part of this panel, and I did respond to Nancy directly, but I would highly recommend that she notify Mary Helen Lopez with probation chief and myself, and I sent her my email so that we can start an evaluation process.
And sometimes when someone is on probation, I actually do get people in my mental health court that are already on probation, and the probation officer notices that their non-compliance is due primarily to mental health issues. I have quite a bit of them, and I don't mind. I'll take them right into the mental health court. They'll have to get an extension, of course, because the mental health program is 12 months long. But yes, that is something that can be done.
I also like to respond to that, because this is why the 1622, that form is so important, and it informs the judge, because the judge is actually who supervises the probationers. The probation officers monitor their compliance with the judge's orders. So the CSOs should also report that through the CLO, the court liaison officer, to the judge. So the judge can take action. In my court, I usually have a compliance hearing, so that, or a performance review hearing, so that we may examine all the options and resources that are available to assist that person in becoming successful on probation. It's really, and then also the probation does have a mental illness caseload, and we must make sure that they're appropriately placed within the appropriate proper caseload that would be able to give them more the attention that they need. This has happened to me recently, and it has been brought to light that we need to really pay attention to the contents of the 1622 form.
I know that is Judge Uzuma and I have found that we've only been on the bench going on 2.5 years, but no one seems to know what those red envelopes are for. And I make it part of my process when I'm on the bench that as I'm calling the docket each morning, I will notate each case that has a red envelope, and I'll tell the attorney, are you aware that your client had a mental health interview assessment done? And about 99% of the time they are not aware, No one even seems to know what those red envelopes are. I didn't even know what those red envelopes were. And as we were learning this through the 16.22 committee, and it's all about educating the ADAs, the defense attorneys, and just the community at large what these red envelopes contain. It does not violate the HIPAA laws, and it's just really a useful tool for the attorneys to use in defending their clients. It's so many different ways. It can be used in punishment phase. It can be used to, if the client some kind of way absconds and the judge is making a decision on a bond, another bond for the client. I mean, it's just a useful tool. And I'll get this confusion when I say this to the attorneys, and they'll say, well, no, I'm my client doesn't want to go into your mental health court. Well, it really is not for that purpose. This 1622 is something that's given to everyone that is arrested that needs that, that where credible information is received. And I just really want the defense attorneys, especially on this Zoom, and yes, it does apply to felonies and misdemeanor cases, that these red envelopes are in the file. Now I'm told that the contents of the envelope are part of e-discovery, that attorneys should be able to access it on e-discovery, but I've not found one attorney yet that has said that they found it on e-discovery.
I'm
sorry.
Oh, go ahead. It's just that it is sporadic, and the 1622 process committee is really very committed to making sure that it becomes a reliable thing, because this has just been brought to a very heightened focus in the past 2.5 years since Judge Huff and I have been on the bench. It is so important for us to be able to consider it in all phases of the legal process and the criminal, in the justice system, as we're going through for the defendant to be able to receive the appropriate resources, as for the safety of the committee, of the community, safety of that defendant, their family, and everybody who comes in contact with them, if you think about it, so that they get the proper resources and referrals.
Yes.
One of the things I failed to mention is that we have 8 public defenders who are working 24/7 around the clock, trying to determine who these people are in need of help. If they are on a motion to revoke probation issue, sometimes we can get them help despite the fact that they did not receive it or they slipped through the cracks the first time. If they come back and there's an indication, then we will make it our business to ensure that those persons do receive that treatment if they can. But I can't speak highly enough for our 8 public defenders at Jack. These people are extremely client-centered. They make me proud to say I work with them. And if you are looking to find out what's happening over there, talk to your clients and ask them, were you represented by a public defender? And I guarantee you, they will tell you that they were spoken to by a public defender who was doing nothing but looking out for their best interests. So we try not to let any of them fall through the cracks.
No, the public defender, I have two appointed to my court, and they do excellent work. They're very useful. I can't speak highly enough of them either, Stephanie. And I make sure that they also know about these red envelopes, because from the beginning, this whole process that Judge Zoom and I reported on, everything that the sheriff is doing, everything that the magistrates are doing, everything that the stakeholders are doing, to get all of this is done in a report to be provided to the ADAs, the judges, and the defense attorneys. And if the main stakeholders are not getting the information to aid them in defending their clients, what is the purpose of everything we're doing, including the Sandra Bland Act, to this point? And I saw some questions that some attorneys are saying, I've never seen that in this e-discovery, but I'm told that, let me ask Jessica, how do the defense attorneys obtain the contents of this 1622 report?
Yeah, thank you. I saw that. So, well, one, I'm not an attorney, so I don't have access to discovery. So how that process works is when the clinician completes the assessment, and Ms. Brown showed what that looks like, the Tacomie, because that's what you would be looking for, that last form. And I can pull it up again so I can show you. But it's the Tacomie collection of mental illness report, and it will have their diagnosis on there. That's submitted to district clerk. District clerk uploads it into file 360. then it goes from 360 to Veripic, and then from Veripic, it goes into e-discovery. So if there is an attorney on here who has access to e-discovery, has ever seen the Tacomie, it's the form by many names. It's the Tacomie form, the 1622, the SB 1326. But what it is that last one, and I'll pull it up again in a second. So Sally, as a prosecutor, do you see this in e-discovery?
Yes, and it's referred to as mental health assessment. And our court files, of course, we've all been on Zoom, so no one's actually held the court file lately, but the court files are stamped mental health assessment. So our clerks are pulling them up from file 360 and uploading them, and they are going back and doing it a second time. If they see the file, and to get in the weeds, but they see the file is flashing that an assessment is done, but yet haven't been uploaded to 360, then they go back and they re-upload. They go back and check later to see if it's been uploaded. So what defense attorneys should be looking for is something that says mental health assessment. I've seen them there in Mag Court. I've seen them when I'm looking through files for Mag Court. So I know it's being done. I've confirmed with our office that it's being done. There may be some gaps with regard to if the assessment is done maybe a day or two later, like discovered and ordered later, there might be some gaps when the file is created, but we are working to identify those gaps and the reasons for those gaps. And we're going to be working directly with the district clerk's office who have articulated how they upload them and how it works. So
let me piggyback off of what Sally just said. The term mental health assessment was causing so much confusion in the court world that they, in 2018, they actually in the Texas Civil Code redefined it as mental health report or interview, because that's more accurate, because they're really not, they don't want everyone to think that they're actually doing an assessment of a kind. Right. What they're doing is collecting information from the defendants in a report form that the magistrate is then sending out to stakeholders. So I'd be very careful when I'm saying 1622 report, 1622 interview, because that assessment, it caused so much confusion, because that's why I reported earlier about what the 16.22 is not, but it is a report to aid all the attorneys in how they proceed in defense of their clients. And if there is any attorney on this Zoom that has ever seen one in e-discovery, please let me know, because I have not met one yet in my court when I asked everyone every day on my morning dockets.
Well, and maybe could we, I mean, this is probably, we're doing a presentation, but I would like to turn this into a work session real quick. If we have some, because we've practiced it with public defender and with prosecutors to see, and we were able to pull a couple SIDs and like go in there and find some JN numbers. And so maybe if there's somebody on here who is state bar, your private practice, whatever, and you'd be willing to practice with us a little bit, would be great, because our goal is once we actually have the 1622 process, today we're sort of sharing with you, this is something that's law, we've been working on it, we haven't gotten the process all the way there, but we want you to be aware of it so you're at least looking for it, because to the presenter's point, the whole point of this is to identify, screen, assess, and notify the legal system. Somebody has a mental illness, they have the opportunity to access treatment. We want you to know that that process exists and that you should have access to it. If you don't, we need to fix things. And once we have it all nicely packaged up, we will do some focused education with the various stakeholders, including obviously attorneys and defense attorneys. So having said all of that, if we have any defense attorneys on here who would be willing to practice with us, Sally and I can get with you and the clerk and give you some numbers to look up and see if you have access to it. Because my sense is they're in there, but maybe people just don't know how to look for them. But maybe they're just not there. I don't know. I don't know what the issue is, but.
And it's very unfortunate that it's called the red envelope, because that has caused mass confusion with the red files, which we also have. And I mean, it's just a tongue twister. And the attorney also, have you noticed the red envelope? No, Judge, I don't have a red file. and I'll say, I mean the red. I wish they would have chosen any color but the red envelope, because the court system already dealing with red files, which are unindicted files.
Well, the thing is that until we started making emphasis on it through the 1622 process committee and looking into all of this, the Stephanie Brown and Laura Duque, that whole process that they explained was really happening. It's just, the thing is, it is sporadic. I've had some attorneys who said, yes, I've seen it. The education of the attorneys is really, really very important, so that they do know what to look for. They do know that it does come in, and I have inquired to make sure, and they have actually held it up to me in the camera to say, yes, here's the document, I've seen it. So it is very sporadic at this time. Plus, before the 1622 process committee really started pushing for this, for it to be part of the e-discovery, there's some cases that just don't have it. It's just still in the court file. Okay, and so the whole process is being worked on, as Jessica is saying. The whole process, really, the committee is working very, very hard. And I think it's a great idea that she has, that if attorneys do wish to serve as a test group, to be able to make sure that it becomes more consistent, that would be really helpful. And again, I like to say and applaud the Public Defender's Office, because they're my go-to people when I'm looking for resources, as far as what resources are available, what services can be provided. I definitely go to Public Defender's Office and Laura Duque to find out more, because they're great advocates in this particular effort to make sure that those with mental health and mental illness and impaired intellectual disability are taken care of and are assessed properly.
Can I interrupt for a second? Judge Uzumba, can I interrupt for a second, please? Because I think you hit on an important issue there. The fact that the court, the two courts, your court and Judge Huff's court, rely on the Public Defender's Office, I think brings to light a very disjointed and unequal representation of defendants who have been brought before the mental health docket. If the courts are relying on the Public Defender's Office to provide information and resources to defendants, those of us in the private bar don't have access to those resources and don't have access to that information. So we cannot advocate as generously towards our clients that the Public Defender's Office does. We get paid $180. I've had a case where I've been doing this, representing someone since August of last year, July of last year. And she has been sent to the mental health court, referred several times. And for $180, there's no way that we can do a decent job. So I think the courts, even though these CLAN leads are put on, they're great, but the fact that the private bar is not given the resources and the information that the Public Defender's Office has, I think exposes a really great weakness in this.
Amir, that is the reason why Judge Uzumba and I are trying to educate the whole bar about the 1622 process. And the public defenders are in my court. They're doing exactly the same job that you're doing. They don't give me any more resources than any other department at the courthouse. I have to tell them also, just like I tell every defense attorney that comes before me, are you aware that there's a red envelope in your client's file? They sometimes, most of the time, don't know either. There's no difference in my court. They're not getting anything more than what you guys would get. There's no difference to me.
It's not that. The fact that Judge Uzumba said that if she has an issue, she goes to the Public Defender's Office because they have resources. We don't have that as a private bar.
You completely misunderstood me, sir. You completely
Mr. Mallory, you have access to all of those same resources that we do. The only issue is we know about it, and so we utilize them in our little time that we have to visit with your clients. in Jack. You know, we made it our business
Exactly.
to find out what those resources are so that we can make sure that the clients have it. Now, once they leave Jack, they are now your attorneys to represent, I mean, your clients to represent in court. They should have all of that information. So it is up to each attorney to find out, hey, is there something I need to know about? Talk to me about your magistration process. You can even find out for yourself what happened during magistration with your clients, because those dockets are actually videoed and they're recorded. So if you're looking for specific information, you can find out. And we are also available for you to call. Hey, do you recall seeing this client while you were at magistration? We can look up the information and find out what we have that you may need. We are all very available to everyone. It's not just to the judges. We're trying to do everything we can for everyone.
Thank you, Ms.
I
Brown.
never knew that. I didn't know that we could.
Because that is what I emphasized, is I wanted to be able to put out to the attorneys here that I do call. These are the resources that you can go ahead and access, is the Public Defender's Office, because they have been representing folks with mental illness. And Laura Duque, I was just making an emphasis of that, in that I go to them for information, not that they have any, that I rely on them as far as they have any extraordinary resources, but they have exposure, and you can as well. Contact them, as Ms. Brown has just invited you to, and I have just made that emphasis. And you can seek out these resources. And as you know, okay, we're here to be able to assist. And I insist on the defense attorneys as well as the district attorney to be able to look at that 1622 so that we can discuss the most appropriate resources or referrals for those defendants.
And Amir, it is just not the public defenders. We're not saying that the public defenders even know about this 1622 process, because it is across the board. The ADAs, the young ADAs in my court, the young public defenders, other judges, no one seemed to have known what these red envelopes were about and what they were. They were sealed. People were afraid to open them. We're just making the big push now. And this is not something that has just started. These red envelopes have been around for a while. It's just in the last 2.5 years, we've been making a big push to educate everyone about what the content of these red envelopes can do in order to help your client. Now, I've never had an attorney come to me in regard to a bond reduction or reinstating a bond that has said, "Hey, judge, and did you know that my client had a mental health, a 1622, a mental health report done?" Because the Texas Code of Criminal Procedure says that the judge must use that report in assessing if a bond should be assessed or reinstated. I mean, I want the defense attorneys to know this information. I want them to utilize these reports in defending their clients. And it applies to everyone.
Okay, lively discussion.
Oh, and just one more word. I'm sorry, Jessica. This has been enacted since 2017. Since 2017.
Yes, and so here, thank you for pointing that out. Lively discussion. So if you guys, it looks like a lot of these are direct messages to me. So it looks like someone was able to look up and they could see that the mental health assessment was in the felony, but not in the misdemeanor discovery. So Sally, maybe that's something I can get with you and the district clerk on with the ADA's office, and we can explore that if it needs to be in both. And I've had some of you send me some case numbers, so we're gonna look into this. And somebody said that they are just now receiving one for the first time. So we wanna work out the kinks and make sure that, one, the information's in there, two, that it's not an accessibility issue, right? Like maybe only certain people have access to certain things. So this is very helpful, lively discussion. So thank you all. I also want to orient everyone. I think some people were saying, well, anyway, I'm trying to, there's a lot going on in the chat here too. So I want to make
Make sure
Everything's so-
as people are saying they're not seeing it in a misdemeanor, make sure to also include the county clerk, because that's who uploads information as well. So it is in the court files, though. It definitely is in the court.
In my court, if you can't find it anywhere, we'll just give it to you. It doesn't violate HIPAA. If you want it, I mean, Booker, my coordinator, he'll like scan it and just send it to the defense attorneys. I'll say, you got it? No, okay, we'll send it to you later today. So you don't see it in your file, I'll do it.
Well, can I address one other issue, Judge? And it's sort of a side issue. And I think the judges, and I know there's a couple other judges on this meeting, and they need to be aware of it. And this has to be addressed. It has to be addressed at some point. There is no way that a private attorney on the wheel is going to properly represent a defendant for $180, review all the videotapes, the evidence, do the mental health aspect of it, and possibly sometimes the immigration issue for $180. That is not happening. And if the courts don't realize that, you're missing a really, really big boat here. And the courts—
Well, Amir, that really seems like a question for a different panel. We're not discussing the pay of court-appointed attorneys today. We're merely trying to educate attorneys on this Zoom for purpose of the 1622 process. It is a valid question. It is a valid question, but I don't think it's appropriate for this particular panel discussion.
Thank you, Judge. And on that note, I am going to go ahead and wrap us up on this topic because we do need to get on to our next presentation. But clearly, there's a lot to continue discussing and learning here. So thank you all for your input and your questions. And I will continue to look through the questions coming through chat to make sure we follow up. And thank you to the attorneys who are already sending us some case files to look at and who are volunteering to help us improve this process.
Thanks, attorneys. Thank you, attorneys.
Yes, we'll get there and we'll have a follow-up educational session for you.
I would love to do a follow-up of this to the whole court, everybody, attorneys, judges, ADAs, public defenders, to the courthouse. Just on this alone, we could probably do a 3-hour panel discussion just on this, what Judge Grace and I have been discussing today. If you guys want that, let us know.
Thank you, Judge. And we're going to go ahead and transition on to our next phenomenal panelist.